Mr. Goff.
Your Honor, let me begin by making clear that nothing I say should constitute a withdrawal or abandonment of any other sentencing-related or punishment-related motions previously filed. Beyond that, if this were any other case, when it comes to sentencing, I'd be turning to Ms. Dunikoski and saying, Judge, what she said. I agree in a lot of ways that the sentence recommended by the state should be the judgment of the court. But this is not a normal case, and out of an abundance of caution, I do feel like I need to address a few issues, but I'll be relatively brief. And there is one issue that the state's sentencing recommendation did not address. I'm pretty sure I know what the answer would be. It won't take them long to give it, but I would put it on the record. Your Honor, like Travis and Gregory McMichael, Roddy Bryan is a first offender. He has no prior felony convictions. Like Travis and Greg McMichael, Roddy Bryan has lived a life, however well lived, that warrants an opportunity and potential for redemption and rehabilitation. I would ask the court to consider the entirety of the record in the case, including the transcripts of the pretrial proceedings, including the bond hearing in this case. I'm not going to go through a whole bunch of Roddy's family history and circumstances. I know the court is familiar with them. The McMichael defense teams have argued elegantly and persuasively for sentences of life with the possibility of parole, based on the grounds that I've previously discussed. And like the McMichaels, there's no evidence that Mr. Bryan is depraved or among the worst of the worst, and therefore Roddy Bryan should likewise be allowed the possibility of parole. And there is an argument here as to whether or not the life without parole option is an option before the court in this case. I didn't think the state had filed a notice of intent to seek life without parole, and apparently they did file the notice. I'm not sure whether they had intended to withdraw the notice beforehand or what happened, but in this case, the notice, which I don't recall receiving, was filed in September 2020. It was emailed to a Sea Island address, not mine, which would be consistent with it not having been properly served. And I would take the position that due to a technicality beyond the control of the state in this case and beyond the control of the court, and the service was by the previous Chief Assistant Jesse Evans in this case, that technically, not having been served as provided in the certificate of service, that the notice is defective. There still remains an issue as to whether the court can could impose sentence anyway without that notice, and that would require the court's resolving two competing statutes. You have the sentencing statute itself, and then you have 1716-4 under which the notice was provided. We would suggest a rule of lenity indicates that where the notice has not been served, or there's not proof of proper service, that the court doesn't have discretion to impose a sentence of life without parole. I'll let the court think about that. It may be an academic question anyway, particularly given the state's recommendation, which we're certainly not going to disagree with. But going beyond that issue, Your Honor, while Mr. Bryan is also a first offender and also worthy of rehabilitation based on the life that he's lived, as the evidence reflects, that's where the similarity between Roddy Bryan and the McMichael defendants ends. And I would submit to the court that that isn't the beginning of the sentencing inquiry for Mr. Bryan, the end of the sentencing inquiry for Mr. Bryan. I would respectfully submit that it's the beginning. Now, before getting into that, I do want to address one other. Lawyers probably shouldn't use the word technical arguments, but I would contend that count 9 merges into count 8. I don't think alleging separate streets that the chase is occurring on changes it. If someone was chased through the city of Savannah, I don't think that you could argue that there were 15 different attempts at false imprisonment or 15 different false imprisonments. If you went down Montgomery and up MLK and across Broughton and up the President and down Julian, I don't think you could multiply counts that way. I do think that 9 is an inchoate offense that obviously merges into 8. And because the motor vehicle that was used in this case was used in the context of the chase, there's a factual merger. And I think it's more or less the same argument that Ms. Hogue was making, but I could be mistaken. So I want to adopt her argument as well to the extent it's expansive beyond mine, and specifically a recitation of the Knoll and the Hewlett cases. Having done that, I want to get into what I think is where the sentencing inquiry for Mr. Bryan really begins, because this is a kind of unusual case. To me, there are 4 additional factors that the court has to consider in fashioning a sentence here. And then the question becomes how the court does that under the laws of our state. We've already challenged those laws. The court, not surprisingly, given prior decisions of our Supreme Court, whatever standards may be evolving until the Supreme Court says they have, this court applies the law that we have. But there are 4 factors here that I think the court has to the court never has to consider anything I think the court should consider. Issue number 1 is the jury verdict says that Roddy Bryan was not a party to the shooting, nor a shooter. Roddy did not kill Mr. Arbery. He did not attempt to kill Mr. Arbery. He did not intend to kill Mr. Arbery. He had no idea that the McMichaels had guns until moments before the shooting. And that's not just an opinion, that's pretty much a jury verdict. When they acquitted Mr. Bryan, not only at count 1, but also count 2 and count 6, when they found him not guilty of anything related to the shooting, that's a reflection of the fact that Mr. Bryan had no idea of what was about to happen. That tragedy was certainly not something that he could have anticipated up until the moments before. And by saying that, I'm not trying to get back into the charge conference issues. It's a different factor here at sentencing. But Roddy Bryan was not a vigilante. He was not a party to any organized effort to fight crime in Satilla Shores. Roddy Bryan really had no idea what was going on or why until after the tragic death of Mr. Arbery. And I think the state pretty forcefully drove that issue home during its closing argument in this case. That factor really puts Mr. Bryan in a different position. Mr. Bryan isn't the one who brought a gun. He was unarmed. And I think that reflects his intentions, and it reflects a significantly lesser state of culpability. The second issue, Your Honor, is the issue of remorse. Now, like the McMichael defendants, Mr. Bryan faces a federal trial and substantial federal penalties in the event of a conviction. And I would agree with Mr. Rubin that no competent attorney in the state of Georgia under these circumstances would allow a defendant to say anything more than they already have. But in this case, distinguishing again Mr. Bryan from the McMichael defendants, Mr. Bryan has expressed remorse. Whether it's part of the record or not, he expressed remorse about Mr. Arbery's death even before he was arrested on national television. As the family, of course, has not accepted that, and they don't have to, Your Honor, and we can all understand why. But beyond that, when you look at his statements in this case, I think it is readily clear that while Mr. Bryan has disputed and continues to dispute whether things that he did that day constituted crimes, he has never questioned the tragedy of this death and has never expressed anything but remorse over the death of Mr. Arbery. And that does put him in a very different category, I would submit, in a very different posture from the other defendants. And I would remind the court, and I'm not going to spend a lot of time on it because the court heard most of this, but during the trial, the court heard the body cam from Mr. Minshew. Mr. Bryan admitted from the get-go that he chased after Mr. Arbery, that he was uncertain as to whether they should have done that. He wasn't running around the scene trying to influence witnesses' testimony, as the state alleges other people have done. He was very candid and straightforward, and you heard his demeanor on the video at the crime scene. You heard the excerpt from the interview with Detective Lowry, and of course the court has the entire statements in the record, where Mr. Bryan expressed, again, regret that Mr. Arbery died. He pointed out that, if his vehicle had collided with Mr. Arbery, maybe Mr. Arbery would still be alive. And not in the context of wanting to hurt Mr. Arbery, but in the context that maybe he would still be with us, and this tragedy might have been something less. Beyond that, Your Honor, there were a number of statements made to investigator Sechrest, Special Agent Sechrest, during the investigation of this case, which technically, I believe the statements themselves, the transcripts and the videos, were admitted into evidence at the Jackson v. Deno hearing. At least that's my practice. I don't have a transcript to look at, but that's normally what I do. And moreover, I think they were tendered in connection with the preparation for the trial itself, and I think technically during the trial, they weren't presented to the jury, but the court can consider those. On May 11th, Mr. Bryan, I'm referencing page 69 of that transcript, indicated that he did not want to see the video in the aftermath of the shooting. He didn't enjoy it. He didn't take any pleasure in that. On May 13th, at page 75, Roddy Bryan expressed shock to Agent Sechrest at the shooting of Ahmaud Arbery. Referencing page 100 of the transcript, Roddy thought it was that what Mr. assumed, thinking might be putting too much credit to Mr. Bryan, Roddy Bryan assumed that Mr. Arbery had done something more serious, that there was more to it than going through an open, unsecured construction site. And that doesn't change the lawfulness or unlawfulness of his conduct, but it does reflect on his level of remorse. At page 101, Mr. Bryan says that to Agent Sechrest, and these are all statements that the state could have used at the trial against him had they wished to do so, and may still be used against him in federal court. None of these statements are without consequence. That he was sorry that Ahmaud Arbery died, that he wished he had stayed on his front porch. He's not going around boasting to people or bragging about it. He's regretful way back then. And that is before he was arrested. At page 102, he regretted having got involved in the chase. And, Your Honor, I think when you take those statements in conjunction with the rest of the evidence in this case, Mr. Bryan has done everything he could do, short of confessing to committing felonies on national television, that he is remorseful and regretful at this tragic loss of life. And it's difficult for me to conceive what more he could do. Now, is the Arbery family going to be satisfied with that? No. They don't have to be satisfied with that. You have to give credit. 3 members of his family came up here and probably did what were the most difficult things they've ever had to do, is to come speak here in this court on national television, effectively, about the death of their child and their brother. And that's difficult. But whether or not they accept Mr. Bryan's expression of sorrow and remorse for the death of Mr. Arbery, it's for the court to decide whether Mr. Bryan has expressed remorse, and if he has, what to do about it. And the court may well decide there's nothing the court can do about it. The felony murder statute prescribes one punishment, a mandatory minimum of life. And I'm not reviewing the legal argument there. But if there's a way the court can take it into account, I'm going to argue that the court should. The last issue, Your Honor, and I think the court is well familiar with it, is Mr. Bryan's full cooperation with law enforcement from day one, from moment one, from minutes after the shooting. I'm not going to belabor all the different things Mr. Bryan did, producing the cell phone, the night out video, the numerous statements, going through the area where the shooting took place with the police to help them understand what happened that day. On a scale of cooperation, you'd have to put Mr. Bryan at a 10 out of 10, even a 12 out of 10. I've never seen a defendant provide that kind of cooperation. Most of it without the benefit of counsel. Slick lawyers didn't tell Roddy Bryan to turn over the cell phone, to talk on the scene on the body cams, to go down hours later to the police department. Roddy Bryan did that because he wanted the truth to be known, whatever that was, whatever it meant. So these are all factors above and beyond anything that apply to the McMichael defendants as to why Mr. Bryan should receive a lesser sentence. Now, the mandatory minimum in Georgia is life imprisonment on a felony murder. I'm not going to rehash the legal arguments. What I am going to suggest to the court, though, and given the age of the defendants here, whether Mr. Bryan is eligible for parole or not, he's going to be 80 years old under the current guidelines before he could be eligible for parole. And effectively, even if the court grants life without parole sentences, as the state has requested, to the McMichaels, simply giving Mr. Bryan a sentence of life with the possibility of parole, still, given the respective ages, means that he would essentially serve the same sentence and that there would be no options there. So I'm asking this court to consider sentencing Mr. Bryan and Mr. Bryan only under OCGA 17-10-1B, which, at least in my experience, is relatively rarely employed, but perhaps underused, especially given the evolving standards of with respect to sentencing issues. Under 17-10-1B, as I understand it, a request for relief from parole restrictions may authorize consideration by the parole board of parole prior to the completion of any specified time period otherwise required prior to parole eligibility. Imposing sentence under this statute does not grant Mr. Bryan parole. He still may never receive parole. He could still die in prison 50 years from now, even if the court grants relief under 17-10-1B. All that does, however, is it gives the parole board the freedom, if you call it that, the ability to parole Mr. Bryan whenever they see fit, regardless of any statute or rule that would otherwise prevent it. Now, Mr. Bryan still has a long road here to establish the redemption and the rehabilitation that would justify his ever being released from prison. So, as I've explained to Mr. Bryan, this doesn't guarantee him that he would do 1 day less in prison than he would otherwise do under the sentence that the court is about to impose. But what it does do is provide the opportunity for the parole board to exercise its discretion in deciding whether to release Mr. Bryan when they believe it would be appropriate and not based on some arbitrary, preconceived, mandatory minimum time period before he could be considered. And I believe that this is that rare, exceptional case where relief under 17-10-1B, however fleeting it might be, depending on the circumstances, that this is a case where that would be appropriate. And I would respectfully submit to the court that as a practical matter, it's really the only relief that the court can give Mr. Bryan to reflect his cooperation, his expression of remorse, and the other factors that I've reviewed with the court today. And that doesn't change the sentencing recommendation. I'm concurring with the state, putting aside the legal arguments about merger and vacating of sentences. I'm agreeing with them that the sentence of life plus 15 consecutive probation, that would be the appropriate sentence in this case. I think the only thing that we really are disagreeing about at this point is I'm expecting the state is not going to be excited about 17-10-1B, but I'm asking the court to do that anyway. And in this relatively small instance, and again, it may be completely meaningless depending on how the parole board views things 10 and 20 years down the line, but it is really the only thing, short of striking down parts of Georgia's sentencing law on constitutional grounds, it's really the only thing this court can do that would substantially reflect the wide chasm in differences in culpability and other issues between Mr. Bryan and the McMichael defendants. It's really, it's all that this court really has available to do that. And if for no other reason, that's why I would ask the court to do so. But I do think it would be in the best interest of justice. I mean, Your Honor, Roddy Bryan probably, I won't say he's unique, but he's pretty as close to unique as you can get in our criminal justice system.